Almost every American believes they understand free speech. People say, I can say whatever I want. It's a free country. The First Amendment protects me. But the reality is more complicated. Freedom of speech is one of the most powerful protections in American law, and one of the most misunderstood. The truth is this: free speech has limits. Those limits are legal, and most people do not know where they begin. Welcome to American Laws Explained, where we break down U.S. laws, rights, and government power in clear, plain English. This episode is for educational purposes only and does not provide legal advice. Laws and interpretations can evolve over time and may apply differently depending on context. Our goal is understanding, not argument. Freedom of speech comes from the First Amendment to the United States Constitution, which states that Congress shall make no law abridging the freedom of speech. Notice what it does not say. It does not say all speech is protected. It does not say speech has no consequences. It does not say private organizations must allow speech. It limits government power, not society itself. That distinction is the foundation of everything that follows. One of the biggest misunderstandings is who the First Amendment applies to. It restricts federal, state, and local governments. It generally does not restrict private employers, social media companies, or private businesses. You may have a right to speak, but not necessarily a right to a specific platform. That surprises many people. The Constitution protects you from government censorship. It does not guarantee you an audience, a microphone, or freedom from social response. Freedom of speech was not designed to protect polite speech. It was designed to protect unpopular ideas, criticism of government, and political dissent. The founders believed power becomes dangerous when criticism is silenced. Disagreement is essential to democracy. That is why the protection exists. Legally, speech includes more than spoken words. Courts have recognized protection for writing, art, symbolic actions, protest, clothing, signs, and certain forms of expressive conduct. Speech is broader than conversation, but it is not unlimited. No right in American law is absolute. Free speech exists alongside competing interests: public safety, order, protection from harm, and national security. Courts constantly balance these interests. The real question is not whether limits exist. It is where they are drawn. Over time, courts have identified categories of speech that receive little or no constitutional protection. These include true threats, incitement to imminent lawless action, defamation, obscenity as legally defined, fraud, and certain forms of harassment. This is where confusion often begins. Speech that encourages illegal behavior is not automatically illegal. The legal standard for incitement is strict. To lose protection, speech must be intended to produce imminent lawless action and be likely to produce such action immediately. General advocacy of ideas, even extreme ones, is usually protected. Immediate calls to violence are not. Timing and context matter more than emotion. A true threat is more than offensive or angry language. Courts ask whether a reasonable person would interpret the statement as a serious expression of intent to cause harm. Context matters, tone matters, circumstances matter, audience matters. Not every aggressive statement becomes illegal, but credible, targeted threats can lose protection. Freedom of speech also does not protect knowingly false statements that damage someone's reputation. Defamation includes libel, which is written, and slander, which is spoken. Public figures must prove actual malice, meaning knowledge of falsity or reckless disregard for truth. Private individuals receive stronger protection. This balance is meant to protect open debate while limiting deliberate falsehoods presented as fact. Obscenity is another narrow category. Many assume it simply means offensive content. Legally, it is far more specific. Courts apply tests that examine community standards, explicit sexual content, and whether the material lacks serious artistic, political, or scientific value. Most controversial expression does not meet this threshold. One of the most misunderstood facts in American law is that hate speech, by itself, is generally protected. There is no standalone category that removes protection simply because speech is hateful or offensive. Speech loses protection only when it falls into another, unprotected category, such as true threats or incitement. This principle remains controversial, but it is deeply embedded in constitutional law. Certain actions count as speech if they communicate a message. Protest demonstrations, wearing symbols, silent expression. These can all be protected forms of symbolic speech. Government may regulate time, place, and manner, but not viewpoint. That distinction allows order without censorship. The same words can be protected in one context and illegal in another. Courts consider location, audience, intent, immediacy, and potential harm. Free speech law is deeply context-dependent. Simple slogans often fail because the law itself is complex. When the government speaks, different rules apply. The government may promote certain messages, set policies, and choose what programs to support. The First Amendment limits censorship. It does not prevent the government from expressing its own views. Modern confusion often centers on social media. Most platforms are private entities. They may set rules, remove content, and moderate speech. This is generally not a First Amendment violation because the Constitution restricts governments, not private companies. Legal protection from government action is not the same as protection from platform policies. In schools and workplaces, speech rights can be more limited. Courts allow restrictions when speech disrupts operations, interferes with safety, or conflicts with institutional goals. Context changes the level of protection. Many people imagine free speech as unlimited personal freedom. In reality, it is a legal shield against government censorship, not a guarantee of approval, agreement, or consequence-free expression. Understanding that changes expectations dramatically. Where speech happens often matters as much as what is said. The Constitution protects expression, but it does not guarantee that expression can occur anywhere, anytime, or in any manner. Courts divide government-controlled property into categories that determine how much control the government has. Traditional public forums, such as public streets, sidewalks, and parks, receive the strongest protection. Government restrictions here must meet strict standards. That is why demonstrations often take place in these locations. Designated public forums are spaces the government has intentionally opened for expression. Once opened, rules must be applied fairly. The government cannot favor one viewpoint over another. Limited or non-public forums, such as certain government offices or administrative spaces, allow broader regulation as long as restrictions are reasonable and viewpoint neutral. These distinctions explain why two protests may receive very different legal treatment. One of the most important principles is time, place, and manner restrictions. Government often cannot ban speech based on content, but it can regulate logistics. To be lawful, these restrictions must be content neutral, serve a significant government interest, and leave open alternative channels for communication. Content-neutral rules regulate how speech occurs, noise limits, permit requirements, crowd control measures. Viewpoint discrimination occurs when government favors one opinion over another. That is almost always unconstitutional. Permit requirements for protests often raise suspicion. Legally, they are generally allowed if applied fairly and consistently. They exist to coordinate public safety and manage traffic and crowds. Government cannot deny permits simply because it dislikes the message. Protest is protected. Violence, vandalism, blocking emergency access, or direct interference with lawful activity are not. The line between protected protest and unlawful conduct depends on behavior, not message. Courts distinguish between speech and conduct. Holding a sign is speech. Damaging property is conduct. Chanting may be protected. Direct threats may not be. Two individuals at the same event can face different legal consequences based on actions. The First Amendment protects both protesters and counter-protesters. Government must remain neutral and protect competing rights equally. Free speech often means tolerating opposing voices. Hostile audience reaction cannot automatically justify shutting down speech. If speech could be silenced simply because others object strongly, unpopular ideas would disappear. Government may intervene for safety, but not merely because a crowd disagrees. Certain locations, courthouses, polling places, schools, allow more restrictions due to competing rights like fairness, access, or privacy. Again, the goal is balance. Government employees retain speech rights, but those rights change when speaking as part of official duties. Courts distinguish between speaking as a citizen and speaking as an employee. Speech made in official roles receives less protection to preserve government function. Arrests during protests do not automatically mean rights were violated. Refusing lawful orders, trespassing, blocking streets without permits. These can lead to lawful arrest even when the underlying message is protected. When debates turn to hate speech, misinformation, or offensive ideas, emotions rise, but the legal framework remains structured. Offensive speech is generally protected. It loses protection only when it crosses into true threats, incitement, defamation, fraud, obscenity, or criminal conduct tied directly to speech. Incitement requires intent and imminence. True threats require seriousness and credibility. Defamation requires false factual statements that damage reputation. Fraud involves intentional deception for gain. Obscenity is narrowly defined. Harassment focuses on targeted conduct that interferes with rights. Misinformation, by itself, is often protected. The law hesitates to give government broad authority to determine truth. False speech becomes punishable when it causes legally recognized harm, such as fraud, perjury, or defamation. American law protects more speech than many other democracies. The underlying philosophy is that government censorship power can expand unpredictably. Broad protection is seen as safer than concentrated control. That choice carries trade-offs. Offensive ideas circulate, harmful opinions remain visible. Social conflict can increase. The system accepts those risks to limit government authority. Free speech does not protect against social consequences. People may face criticism, backlash, loss of employment in private workplaces, or removal from private platforms. Legal protection is not social immunity. Courts generally avoid moral judgments. Their role is not to decide whether speech is good or bad, but whether the Constitution permits government punishment. That neutrality can feel unsatisfying, but it prevents judges from becoming arbiters of ideology. Technology has amplified every speech debate. Ideas spread instantly. Audiences are global. Anonymous voices multiply. Yet the underlying constitutional principles remain stable. The scale has changed. The speed has changed. The legal foundation has not. Every speech debate returns to the same tension. How much risk should society tolerate to protect freedom? Some argue for stronger limits to prevent harm. Others warn that expanded censorship creates dangerous precedent. The Constitution manages this tension by requiring government to meet high standards before restricting expression. Free speech does not guarantee equal outcomes. It protects the right to speak, not the right to be heard equally. It does not promise comfort. It promises limits on government power. At its core, free speech is restraint. It is the belief that open disagreement, even when uncomfortable, is safer than controlled silence. It protects ideas not because all ideas are equal, but because granting government authority to decide which ideas survive is considered more dangerous. Understanding free speech requires abandoning slogans. It requires recognizing that rights are legal boundaries, not shields from criticism. It requires accepting that freedom includes exposure to ideas we dislike. Speech protection in America is broad, but not unlimited. It protects ideas, even offensive ones. It restricts speech only when it creates specific, legally recognized harm. It draws lines carefully, often cautiously, because once censorship power expands, it rarely contracts easily. Freedom of speech will always be controversial. As long as people disagree, speech debates will continue. The law does not eliminate conflict. It creates a framework where conflict can exist without government suppression. At its core, free speech is a gamble, a belief that open expression, even when messy, preserves liberty better than enforced silence. It demands restraint from government and tolerance from society. If you now understand that free speech is not unlimited freedom, but a structured legal boundary on government power, then you understand the foundation of the First Amendment. It does not promise comfort. It promises limits. If this episode gave you clarity, leave a comment with the next topic you want covered. And if you want to understand the law, not just argue about it, subscribe to American Laws Explained. Because understanding the law doesn't require shouting, it requires clarity.